In this training module, I'm going to show you how to determine who should be listed as an inventor on a utility patent application. This includes distinguishing between inventors and non-inventors. By the end of this training module, you should be able to determine who is an inventor and who is not an inventor for your provisional patent application. Let's get started. Before we talk about who is and is not an inventor, we should talk about why inventorship is important for patent applications. The first rule that's important here is that all inventors must be listed on the patent application. The corollary to that rule is that all non-inventors must not be listed on the patent application. This is important because a patent application can be denied issuance, or a patent that is issued from a patent application that lists the incorrect inventors can be invalidated if the inventorship is not listed correctly. Now, there are occasions where inventorship is listed incorrectly on accident, and that can be fixed in some instances. However, it's a lot easier to get the inventorship listed correctly up front rather than trying to correct it later. You might find in some cases, if a dispute ever arises about the inventorship of a patent application, the adversarial side of that dispute will almost always claim that the discrepancy in inventorship was on purpose and fraudulent and grounds for invalidation of your patent application or issued patent. So you'd prefer, if you can, to avoid that type of situation. The other scenario that can come up is that when a non-provisional patent application is filed, the filing documents require some signatures from each of the inventors. There are scenarios where that paperwork and those signature documents can be provided after the patent application is filed. However, sometimes you'll find that inventors leave companies, sometimes also on bad terms, or sometimes simply seem to disappear and aren't available and can't be found. This makes it, of course, very difficult or even impossible to get the inventors to sign the required paperwork. Now, there are workarounds in some scenarios to allow other people or attorneys or business representatives to sign on behalf of an inventor who cannot be found. However, the process is not necessarily easy. In fact, it can be difficult enough that some companies simply opt to forego patent rights rather than trying to find an inventor or use the alternative signature procedures. There are a lot of difficulties that can arise if the correct inventorship is not listed correctly, or if the inventors who should be listed don't sign the proper documentation up front and have to be found after the fact to try to fix that. So you want to avoid both of those situations if you can by getting the inventorship correct initially and getting all the proper documentation signed up front. So the rule to determine who an inventor is simple, at least in statement. An inventor must contribute to the conception of the invention. That means the inventor must have come up with part of the idea about a working embodiment of the invention. We'll look in a little more detail at some scenarios of people who should not be listed as an inventor, and that might help to define some boundaries as to who should be listed as an inventor, having contributed to the conception of the invention. It's also important to note that the invention itself is defined as a complete invention when it's reduced to practice. So by defining what the invention is, we can then determine after that point who should be listed as an inventor. So far in your patent application process, we haven't necessarily completed the definition of your invention. I know you've got a lot of details about it, but it's not actually complete at this point. There are two ways to complete your invention. One is to actually reduce it to practice, which simply means making your invention. And some of you may have already made a version of your invention, or made a prototype, or perhaps made several different prototypes. Those are all forms of inventions, but oftentimes, as we're trying to do with your patent application, you might be defining an invention in your patent application that is actually broader than any single prototype that you've built so far. That's where the second type of completion comes in. Constructive reduction to practice is where you file a patent application meeting the filing requirements. So even though you may have actually reduced an invention or an embodiment of your invention to practice previously, the ultimate definition of your invention within your patent application will be correlated directly to what is in your patent application rather than to a single embodiment that you've created previously. So let's look now at some examples of situations and functions and roles that do not rise to the level of inventorship. Someone who contributes general knowledge or obvious elements to a concept is not an inventor. They simply teach people about the technology, or they simply discuss principles that surround the invention that's been made without contributing to the actual implementation of the new invention itself. Similarly, somebody who simply suggests a desired result or outcome is not an inventor. I've had several friends and family over the years who approach me and they say, "Jeff, I have a great invention. Let me tell you about it." And they proceed to tell me about a problem that they discovered and how their invention is that somebody, usually me, somebody should create a solution for that problem. The discovery of a problem by itself, or the suggestion of a desired result or outcome to solve that problem, does not create an inventor because there is no embodiment to ascribe to the invention itself. Also, implementing technical instructions of the people who conceived of the invention is not sufficient to make somebody become an inventor. This is often referred to as technician work. Somebody who simply does some research, or they work in a lab on a problem, or perhaps they're hired to consult or to manufacture prototypes or even actual product. Those tasks in and of themselves do not make any of those functions or roles inventors. It should also be noted that the fact that somebody who is an inventor also does one of these roles doesn't have any negative impact on the inventors. As long as somebody has helped conceive of the workable embodiment or the invention itself, they should and must be listed on the patent application. And anybody who simply does one or more of the things on this list should not be listed on the patent application because they never contributed to the conception of the invention. Now, it's possible that somebody who's initially working in one of these roles might also eventually add to the conception of the invention, come up with something novel, or contribute to a better working embodiment of the invention. And that's fine. Once they do that, they would cross the threshold of having helped conceive of the invention and could be listed as an inventor, as long as their contribution is in the proper location of the patent application, which we'll talk about in a moment. But again, these roles by themselves are insufficient to make somebody an inventor. So somebody who supervises or reviews the work of the inventors is insufficient to become an inventor. Somebody who acts as an advisor to an inventor team is also insufficient. You'll find perhaps in some cultures or in some industries that it's very common for people in supervisory roles to go ahead and add their names to a technical paper or to a document or to a book. In the patent world, that's not okay. Being a supervisor by itself is not sufficient to become an inventor. And if anybody is practicing that approach today, they should be informed quickly that that approach could end up invalidating their patent application or their issued patent. Similar to the general knowledge note above, simply explaining how or why the invention works is insufficient. Similarly, adopting information derived from others is not sufficient to be listed as an inventor on the initial patent application. However, if something is adopted to form a new invention, then that person might be listed as an inventor on a separate patent application. Somebody who simply provides research or additional testing on a device is not an inventor. That would fall into the technician category again. Somebody who supplies known components or starting materials would not be an inventor. So when you go out and you buy your materials from a supplier, simply buying materials from them does not qualify them as an inventor. Somebody who refines or makes superficial changes to another person's design. That's similar to other things we've talked about already. Somebody who provides well-known principles of science, or somebody who simply explains prior art references or the state of the technology. That would be, again, similar to somebody who simply contributes general knowledge about a technological area or a principle of physics. So this isn't necessarily a comprehensive list, but it's a pretty good one. And if you find people who are only contributing to your invention in these ways without having contributed to the conception of the invention itself, then you should be able to let them know that they are not sufficiently qualified to be an inventor on your patent application. And because of the rules that are applied, they actually cannot and should not be listed as inventors so that it doesn't detrimentally impact the validity of your patent application and hopefully issued patent. Now, there's an interesting distinction between different types of patent applications as to who should be listed as an inventor. For a utility non-provisional patent application, the inventorship is determined by the language specifically in the claims. The claims define the scope of the invention, and so it's proper and makes sense that the claims are used exclusively to determine who should be an inventor of that patent application. In contrast to a non-provisional patent application, a utility provisional patent application has inventorship defined by the entire description of the specification itself. And remember, if you do include claims in a provisional patent application, those claims are considered part of the entire description or part of the specification. Since claims aren't required and the entire description is used as the scope of the potential invention, the entire description is also used to determine inventorship for a provisional patent application. I had an interesting scenario one time where a client of mine came to me and they had partnered with a university and they had together put together a provisional patent application on an invention. Now, there was some question as to the type of contribution that the professor from the university had actually made in the provisional patent application. Arguably, it could have simply been general knowledge or perhaps some obvious contributions, but in the end, we listed both the client employee as well as the professor as inventors of the provisional patent application. When a non-provisional patent application was filed for the exact same invention, we listed only the client employee as the inventor, because at that point we made the determination that only the client employee had contributed to the claims in the patent application. When this was communicated to the university had separate counsel contact us, inquiring as to why the professor had not been listed on the non-provisional patent application when the provisional patent application listed the professor as an inventor and had, in essence, identical claims in both documents. We had to explain that inventorship for a non-provisional patent application is tied specifically to the claims, whereas inventorship for a provisional patent application was based on the entire description, and the professor's contribution, if in fact it rose to the level of inventiveness, was limited to a paragraph in the specification and was not included in any of the claims, either in the provisional patent application or the non-provisional patent application. So, after some more discussion and other things, we continued down that path. Even though not everybody else liked the end result, it was the proper result. Similar to a non-provisional patent application, a design patent application is based on the illustrated design. And the reason that's similar is because in a design patent application, the design that is claimed is the actual illustrated design. And so there's a correlation between the illustrated design and the claim of a design patent application. There's also no specification typically provided with a design patent application, and so it really is based on the claim only, which is the illustrated design. Ultimately, what you need to remember for your provisional patent application is that inventorship is based on the entire description that you provide in your provisional patent application. And so you should be mindful as to who contributed to the conception of the invention that you've described in all its variations and forms in your provisional patent application, both in the specification as well as the claims. Also, in terms of the drawings, if you've got information that's conveyed through the drawings but isn't in other places within your patent application, that still would be part of the entire description provided in your provisional patent application. So you want to be comprehensive and look at all of the contributions that have been provided as to who conceived of the invention and whose contributions were included in your provisional patent application. Let's look now briefly at the inventor confirmation worksheet that you might want to use and refer to when you are determining who the inventors are for your provisional patent application. You'll notice that some of the general rules are also listed here on this sheet, and you can refer to these or even provide a copy of this to your fellow inventors or to people who want to be listed as fellow inventors to help them understand what delineates an inventor from a non-inventor. You can also use the bottom half of this form to have everybody who thinks that they did contribute to the invention or conceive of an inventive part of the invention list out the parts of the specification or the parts of the patent application, again, the entire patent application, that they contributed to or that they and other people contributed to together. This is a good way to confirm at this point who everyone believes helped contribute to the different inventive concepts within the patent application. So once you have this list, you can take this list and put it on file and have a record that helps to show at this point in time who everybody believed was an inventor in this provisional patent application. In order to help you fill this out, one place you might want to refer back to is your innovation disclosure form and your innovator profile. Let's look at that now. So I've pulled up a copy of my innovation disclosure form and specifically my innovator's profile related to the tool storage system that we've discussed previously. You'll notice that on this form there is a line here or a box where you might have already filled in specific contributions by this inventor to the provisional patent application. In this case, I'm the only one who's contributed to the invention that's described. I haven't worked hand in hand with anybody else. I haven't consulted with anybody else. I haven't hired anybody else. I don't have any professors who are supervising me. I don't have any government grants or government entities who are supervising me or that I'm reporting back to. So nobody's helped me in this case. If this is your situation, this is an easy question to resolve. You're the only inventor in your provisional patent application and you would list only yourself. However, if you've worked with a team of inventors, or if you think that there might be a dispute in the future as to who was an inventor and who should not be listed as an inventor, you might want to refer back to this portion of your IDF and your innovators profiles to get an initial suggestion as to who should and should not be listed as inventors. And that's it. You should now be able to make an informed decision about who to list as an inventor on your provisional patent application.